What is the condition of free speech in America today? I'm Sanford Unger, Director of the Free Speech Project at Georgetown University. In this video series, Speaking Freely, we're talking from time to time with thought leaders and major players in the free speech drama unfolding in America. Today, Adam Liptak, the Supreme Court correspondent for the New York Times, joins us in the studio. Talking today with Adam Liptak, the Supreme Court correspondent for the New York Times. And Adam, I'm very interested, and I think the people who view these videos on the Free Speech Project website would be interested in your evaluation of where the Supreme Court sits today in a historical perspective on free speech.
This is the court led by Chief Justice John Roberts, is a very strong pro-free speech court, although we might mean something different by free speech today than what, say, the Warren Court thought about free speech. This court protects the classical free speech values of the political dissenter and the lonely pamphleteer and the kinds of things that the older, more liberal courts protected. But this court's also pro-free speech in areas that not everyone is on board with on the left, including in campaign financing, where using the First Amendment to justify the Citizens United decision, the court was free speech in that sense.
Yes.
In commercial speech, the court is free speech in that sense. In cases involving religion, the court seems to be sympathetic to the view that First Amendment free speech rights are implicated when people object on religious grounds to doing various things.
And are there surprises among the justices in this consensus? I have a sense that some of the normal divisions are obscured. I think of the Snyder v. Phelps, the Westboro Baptist Church case, where it was, I believe, 8-1, and there was quite a coalition of so-called liberal and conservative justices.
You do get lopsided cases, and it's a little hard sometimes to say which is the liberal and which is the conservative side of a given case. The one in the Westboro Baptist Church case, the case about hateful protests at military funerals, was Justice Alito, who does find some kinds of speech just to be beyond the pale. Justice Alito, of course, a conservative. But the other person I would think is fairly weak on free speech cases is a liberal justice, Justice Breyer, who also has his doubts about whether the government shouldn't be able to regulate at least some kinds of speech. So to your point, that's exactly right. These are not the predictable 5-4 breakdowns, except in campaign finance, where they are. The 5 Republican appointees are the ones who are in favor of striking.
Who believe that political contributions are free speech, and to simplify.
Certainly political spending, yes.
Right. Is there some worry that if the composition of the court should change dramatically in the next few years, which of course it could because of the ages of some of the justices, that this consensus behind free speech could break down?
I don't see it. We don't know very much about the newest justice, Justice Gorsuch's views about First Amendment issues on the Supreme Court, but his views on the 10th Circuit, where he served as an appeals court judge for some time, were very much in the mold of what we see on the contemporary Supreme Court. And I would imagine that the next Donald Trump appointee, at least on this issue, will not be out of keeping with what we're seeing on the Supreme Court. So they might be out of step with society. Certainly, the younger generation, my daughter in college, has a different view of free speech than people 20 years or 30 years older. But I think this court will be consistently a free speech court with notable exceptions. When national security is on the other side, free speech falls away. When the reputation of the judiciary is on the other side, free speech falls away. But in most cases, including cases which really involve ugly conduct, these protests at military funerals,
Right.
animal crush videos, violent video games, people lying about military medals, the speech side in all of those cases won, and almost entirely by lopsided majorities.
Let's go back to Gorsuch for a moment. Here he is on the court. He was participated in a couple decisions
Yes.
last term, I think. What's his record on free speech cases? Are there any particular cases from the 10th Circuit that attract attention or that are worth looking at when we try to predict his behavior?
I read a bunch of his cases at the time, and I'm not remembering the particular facts, but I do recall that he didn't hesitate at all to employ the canonical libel decision, New York Times against Sullivan, in a very robust way.
Which
at
is
least
the case
once.
that makes it very difficult to prove libel.
Yes, it makes it hard for public officials and public figures, almost impossible really, to prevail in a libel suit, and he had no hesitation in applying those precedents.
So we think that he would be go along with the consensus. So we think he would go along with the consensus for the most part.
I do, and I think he'll be on board for the project to deregulate campaign finance laws on First Amendment grounds. I think he'll be along for the project to make it harder to regulate ordinary commercial conduct that has a speech element. And the court will this term hear a big case about public unions, which has a First Amendment argument in there that people who choose not to join public unions, the argument goes, have a First Amendment right not to pay agency fees, the equivalent of dues, to pay for collective bargaining. I'll be very, very surprised if Justice Gorsuch doesn't provide the fifth vote to deal a body blow to public unions on that ground.
In the past, there have been some decisions or some participation decisions by justices that seemed anomalous. The one that stands out in my mind right now is the late Justice Scalia on the flag burning case. And it's people remind conservatives sometimes, especially and under the new administration, that when Donald Trump is saying, is giving one of his rhetorically excessive speeches about such matters, to remind him that Justice Scalia voted for flag burning as free speech.
So Justice Scalia loved to tell that story, and all credit to him. He said he has no use as a private citizen for the bearded, sandal-wearing hippie who wants to burn a flag, and that if he were the king, he would throw all those guys in the pokey, but he has to follow what the Constitution commands, and he says the First Amendment says you can engage in flag burning. And that's a good lesson, that judges, justices don't always follow their policy preferences. Sometimes they feel they're bound by the law to do things that they wouldn't want to do. I wouldn't oversell it, though. It's hard to find too many examples of that kind of conduct in the First Amendment realm, and really, except for a couple of areas of criminal law, other realms where Justice Scalia wasn't a reliable conservative vote. But those are legitimate. Now, political scientists have done studies of how justices vote in free speech cases, and the political scientists find that they tend to protect speech that they like, the content of the speech that they like, and tend to regulate the speech.
What are some examples of that occur to you? And endorsing speech they like, where's that? I mean, because, for example, the Westboro Baptist Church case does not fit in that conclusion.
Yeah.
None of them said they liked that speech, or I don't know anybody who does like that speech particularly.
No, I don't think anyone's in favor of that speech. I think you're going to have to give me a minute to think about it.
That's fine.
I'm
Yeah, I'm sorry. I didn't. That's a little bit of an unfair
No,
question.
it's perfectly fair. And you know, let's circle back because things will occur to me.
By all means. Are you surprised by the devotion of Chief Justice Roberts to free speech? He appears to have. I think some people didn't expect him to be as committed to free speech as he seems to be.
I guess that's right. I mean, he's been on the court now since 2005. And on the court, he has not only been a consistent, almost consistent, there are exceptions, a strong proponent of free speech rights, but he's also done something unusual where he takes great care to spread out the good cases to the other justices,
Right.
but he tends to disproportionately keep the free speech cases for himself. So he's written a lot of the major free speech cases, and he seems authentically devoted to it. Although, in the two major exceptions to pro-free speech, Holder against Humanitarian Law Project, where Roberts writes the majority opinion saying that someone who ran afoul of the material support law forbidding aid to terrorist organizations by providing speech-related benign help could nonetheless be prosecuted. That was Roberts, so that's a case where free speech doesn't win. And also a case where Florida and many other states try to do a little mild regulation where state court judges run for election. And there was an ethics rule that said you can't personally ask for money if you're running for a judicial office. And a lot of people thought that was a free speech problem. Chief Justice Roberts, joining the four liberals, 5-4, says no, we're going to sustain that ethics regulation. So national security, judicial dignity, there are areas where he's not that strong,
Right.
but in general, you're quite right, he is.
One of the cases that I've followed over the years, or have remained interested in over the years, is the Pentagon Papers case, which I covered as a young reporter at the Washington Post many
I
years ago.
understand there's a movie coming out.
Yes, about the Post, of all things.
That's
That's another matter.
I suggested to my friends at the Post that we should have a movie about how the New York Times broke the Watergate scandal.
Right, right. Yes, a lot of tension, a lot of awkward feeling about why this is being done about the Post. But some people like to speculate, all these many years later, about the Pentagon Papers case from 1971, whether courts would reliably continue to rule in favor of the media, of two major newspapers. Washington Post was not a national newspaper at the time, as it did 6-3 on the occasion of the Pentagon Papers publication, ruled against the Nixon administration. What do you think about that? You mentioned that national security is potentially one of the exceptions.
I think this kind of law is contextual. That was in an era where there was widespread distrust of the Nixon administration,
Right.
and widespread respect for the major news organizations who were sort of trusted partners in governing the nation. So if the Washington Post and the New York Times decided something was worthy of publication, the editors of those papers were sort of the peers of their counterparts at the State Department and the Justice Department and so on. And I think in that climate, we got the benefit of the doubt. I don't know that in the current climate, those news organizations, to say nothing of BuzzFeed or the Huffington Post,
Right.
would get the same kind of answer. So we have these high-minded, neutral-sounding legal doctrines, but judges apply them in the context of the times.
Sure, they're pragmatic. They
Yes.
follow the election returns.
And as you know, Sandy, the Pentagon Papers, controversial though they were historical.
Yes.
Very hard to say they're endangering current military operations.
Very difficult case to make then, and Erwin Griswold, then the Solicitor General, said a few years later that although he argued on behalf of the Nixon administration that continued publication would damage national security, he didn't believe it himself.
Yes. And I was just reminded yesterday, I was on a panel, that Alexander Bickel was asked a question, I think by Potter Stewart, saying, well, what if we knew for a fact, Mr. Bickel, that tomorrow 100 young men would die as a consequence?
Yes.
Would you still take this position that the First Amendment protects you? And he said, at that point, my impulses toward the First Amendment might yield to my human impulses. Which goes to your point, it really depends on the factual context.
Sure.
And then, interestingly, the ACLU sent in a supplemental brief disavowing the Bickel comment, taking the hardline First Amendment view that, we publish the truth and let the chips fall where they may.
Right, right. Well, Bickel, in that case, a lot of people said that he didn't argue as hard a First Amendment line as he could have at the time. Maybe it's because of that one answer.
Well, and if I'm recalling right, he was a strategic choice. He was
Right.
a well-known conservative, but he wasn't a well-known appellate lawyer.
Right. Good point. So maybe it was not the best choice.
It worked out. And it got Floyd Abrams to start in the
Right,
business.
and so that brings us to Floyd Abrams, and often regarded as the leading First Amendment lawyer in the United States
I believe
today.
he is, yes.
And he is not always so predictable, and I think it's, for a time he was, and then when he represented Mitch McConnell, the Senate Republican leader in the Citizens United case, some people were very surprised by that.
Well, I agree that he's occasionally unpredictable, but I don't think that's the right example. I think Floyd thinks that what the First Amendment protects at its core is speech about politics. It doesn't want the government meddling in, censoring speech about politics. And as he viewed the Citizens United case, which after all was about whether the government could
Right.
punish the distribution of a documentary about a political candidate, Hillary Clinton, he thought that fit very nicely into classical First Amendment thinking, that you don't want the government telling people, even corporations, not to spend money on speech about politics.
So I don't mean to suggest that it wasn't a principled decision on his part. It just disappointed a lot of people at the time.
Floyd was for a long time an uncomplicated hero to liberals.
Right.
And then when he started to, take the same principle he used in defending the press to defend Citizens United, to defend bond rating agencies and so on, then people had a more complicated reaction to it. But you can really ask the question of who's being inconsistent. And in political terms, maybe Floyd's being inconsistent. In First Amendment theory terms, maybe Floyd's being consistent.
Right. Well, he certainly argues that in his recent book on,
Yes.
on this issue,
Yes.
in which he appears to be defending very strongly his position on the Citizens United case.
I don't think he has any second thoughts,
No, I don't think
any
he does
doubts.
either.
And I think viewed through the lens of, let's step back a second. There was a time not that long ago when a lot of people on the left had problems with campaign finance law. The ACLU had problems with campaign finance law. The AFL-CIO did. The Reporters Committee for Freedom of the Press filed a brief on behalf of Citizens United the first time it was argued. So
Easy to forget that.
the old coalitions are breaking down as the right more and more strategically embraces First Amendment law as part of a deregulatory project to go after all kinds of campaign finance, commercial speech, all religion, all kinds of laws, and successfully so.
And it seems increasingly to be a mistake to try to divide First Amendment decisions, free speech issues into liberal and conservative matters, because they're not. It's not predictable. I mean, the notion that today many young people, as you suggested earlier, in colleges and universities, do not hew to what we think of as the classical defense of free
Yes.
speech, is an interesting
Right.
development.
I think on campus and among younger people, equality and dignity matter more than liberty. That and those are important values on both sides, and people have to be thoughtful about it. But the classic First Amendment theory says, let people say what they like. The best response to it is more speech, and it'll all get sorted out in the end. The new thinking among younger people is some of these statements are deeply, profoundly hurtful, marginalize people, destroy their dignity, and they ought not be allowed, particularly in settings where you're trying to have a civil discourse in an educational institution about what we should be doing. And these two ideas are very hard to reconcile.
Right. In the events at Charlottesville in August of 2017, I think a lot of people were suddenly startled that their classic definitions of free speech might be challenged.
Yeah.
When some of the speakers were armed, when they were really quite intent upon violence, or so they admitted afterwards. What does that do to free speech theory?
once you inject the real imminent threat of violence, free speech has nothing to say about it. That you can the police should take action if there's actual imminent threat of violence.
Right.
So an aspect of the Charlottesville case is easy. But when the ACLU went to court on behalf of the marchers, they went to court on the understanding that there would be profoundly ugly speech peacefully presented.
Right. I don't think they
and that
knew
drives
about
people
that.
crazy too.
Right.
Yeah, no, they didn't, and they're now taking the position that A, they're not going to defend anybody who wants to be armed while they're protesting, and B, they're not going to, their doors aren't open to everybody always because they have limited resources. But in general, the ACLU, let's go back to the Skokie case when
Right.
Neo-Nazis wanted to march in an area of Illinois with a big Jewish population. And no question that this would be a profoundly hurtful thing, but not dangerous, and these people were marginal groups.
Yes.
Without sort of the wind of the Trump administration sort of in the mix. So again, the historical context matters to how you think about and what the courts do about First Amendment law. And I think Charlottesville is a profound test for all of this.
I think it is. I think it's a watershed event, and I think that some people are startled to find whom they are defending.
Yes.
And thinking about it, even when you think back to Skokie, and now I can't remember who was president at the time of the Skokie March. It might have been Jimmy Carter.
I was thinking it was early 70s. Yeah, maybe Carter.
Yeah. Well, of course, if it's Carter, it's unimaginable, especially unimaginable to think that he would have said there's some fine people proposing to march in Skokie the way Trump said,
Right.
repeated about
But
Charlottesville.
I guess the real question is, let's take the violence out of it. Let's just assume that neo-Nazis want to gather in a public park in a significant American city and say horrible things. It used to be that right and left were united in thinking, that's ugly, that's horrible, it's distasteful speech, but we're going to protect it, the First Amendment protects it. And I don't think we have that consensus anymore.
No, I think that is bound to affect other people who are seeking to speak publicly and spread.
And then you have questions like, that gives rise to a massive counter-protest, the possibility of violence, requiring, say, the University of California system to spend on a single event hundreds of thousands of dollars to keep the peace. Is there a point at which, as a practical matter, you just can't have that anymore? I mean, the state of California has a lot of money, so I would hope that they, I would hope that they would work very hard to let both sides say their piece and to police it as necessary.
It's a little difficult, though, to argue that educational institutions should be spending hundreds of thousands of dollars on protecting people who are clashing with each other in the streets, rather than
it's not given that they could be spending it on scholarships for poor people.
Exactly, on access to education or on quality of education, et cetera.
But at the same time, the First Amendment does have this concept of the heckler's veto. We're not going to let somebody's speech be stifled because the other guy is protesting too loud. So the whole thing is a rapidly shifting and problematic landscape.
If this is not an unreasonable question, tell me if it is. If the heckler's veto came before the Supreme Court today, what do you think would happen?
I think this court rules, it's generational. I think they would rule as a court 20 years ago or 40 years ago would have. And also, which is to say, they would, absent really extraordinary circumstances, not say you can suppress speech because it's going to give rise to counter speech.
Right. But what would they say about the counter speech? Would they say that it's all right to disrupt the speaker because the disruptors have free speech rights as well?
Yeah, it really depends on the circumstances, but and it really depends on what you mean by disruption, and there's too many factors in play to say what the Supreme Court would do. But They would try to achieve what we used to think was achievable, and maybe we don't think so anymore, which is let both sides talk.
Yes.
Have speech, have counter speech, let people make up their minds based on full information. We have this notion, but this is, you can really ask questions about this in the era of fake news and democratization of information on the internet. A significant part of First Amendment theory is that over time, the truth will come out and people will make the right decision. But that was a little easier when there were trusted gatekeepers of information. Now that information has gone wild, it's harder to know whether the average person is really going to make the right decision.
Well, and it's a fundamental cornerstone of democracy that there be debate and dialogue and issues get talked through.
Right.
What is different now is that so many of those conversations are no longer civil.
Yes.
We thought we could count on civility as a factor.
It's partly that, and there's partly and increasingly no agreed upon set of facts. People come to the table with their own understanding of the facts, and you're never going to have a constructive dialogue if you don't agree on the very premise of what you're talking about.
So is the Supreme Court, I mean, we all revere the Supreme Court, or some of us have grown up kind of revering the Supreme Court and its wisdom, et cetera. Is the Supreme Court up to the current challenge of trying to adjudicate this mess that we have on our hands surrounding free speech?
The Supreme Court can be criticized on many grounds, but it is still easily the best functioning part of our government. It's very able grown-ups work there. They're very committed to, they're not shy. They take the big cases, they decide the big cases, they do it in a serious way. And given what we see in the other branches of the government,
especially now,
particularly these days. And the Supreme Court is also quite alert to the limits of its power. It's not going to go further than what society will accept. But it does, particularly now that they're back to 9, it does think it has an important role to play. And I got to say, in light of some perceived dysfunction in the other branches, I think we ought to be glad to have them.
Absolutely glad to have them. Hopeful that they will be, to some extent, permitted to do their work without constant attack and criticism.
Right. We've seen a lot of criticism, and quite unusual, from the president going after particular judges, particular courts in cases involving his private actions, his public actions, calling the criminal justice system a joke and a laughingstock, which is really shocking to me because the American federal criminal justice system is pretty good. But he hasn't gone after the court yet. Of course, they did manage not to rule on the travel ban. So.
Right. And do you think they will be willing to take on some of these fundamental Trump issues that could put them under fire by the president?
The short answer is yes, but I think they might also do what they did in the first go-round of the travel ban, is issue a kind of moderate compromise, thoughtful interim decision, and cool down the temperature. They're not only about making big bold statements. Sometimes they're about making an incremental decision which takes the temperature down a notch.
The president has gotten quite a bit of criticism for some of the judges he's named to lower federal courts, and that I would think would be an ongoing issue. Where do you see that?
So in the first place, I'd say that the Trump administration has not gotten very much accomplished in Congress, but judges are an exception. Gorsuch, for Republicans and for the Trump base, is a home run. The many judges he's nominating and getting in.
I was not actually referring to Gorsuch. I was talking about some of the conspiracy theorists and other people who've been considered for.
He's nominated by now scores of judges. Many of them are of the highest quality, quite conservative, but really distinguished former law professors and state Supreme Court justices. Less than a handful of them look a little more idiosyncratic, have gotten very poor response from the ABA and so on. So there's some stuff going on, but I don't want to say it's representative.
Right.
I think in general he's appointing quite good people that a Jeb Bush or a Mitt Romney would cheerfully have appointed also.
Of course, it's the others who get the attention,
yes.
and perhaps the media are to be blamed for that. I don't know, but
You know, I mean, some of them, and I haven't studied this closely, but some of them, at least superficially, you can ask, you know, real questions about what they're doing in the mix.
and how does that happen?
That's a good question. How it usually happens is the White House counsel's office, in consultation with the Federalist Society, gets the really good people, and then the local senator's brother-in-law, you know, gets in on the crony ticket. That's what typically happens.
And
someone's college roommate.
Right. That's not an orderly way to select people who are going to be making justice in this country.
Well, you know, there are trade-offs because the Senate has to, you know,
Sure.
the Senate has to vote for the guys you really want, and sometimes they ask for a favor in return.
Right. So in the compromise process, we may get some less than stellar judges.
Right, and then the other problem is that we're so polarized now that the good judges who you know, if you're a Democrat, you should probably go, you know, not my guy, not my type, but the president gets to pick, and they're qualified.
And that was essentially what happened with Gorsuch, I think.
Yeah, in one sense it happened. On the other hand, the vote was very close. I forget what it was, 52-48 or something.
Well, it was a partisan vote.
Yes. But that partisanship is not uniform. I mean, Scalia, everyone knew he was conservative, got a 98-0 vote. Ginsburg and Breyer, if they had 20 votes against them collectively, that's about right. So it used to be that you put up somebody whose credentials were strong, whose temperament was fine, who was a good judge, but his political leanings were one or the other, and the Senate would go along with it. Now we're so polarized that we're not able. You're drawing important distinctions between idiosyncratic judges and highly qualified ones, and they're all getting the same vote. So you're not having the filtering process.
Right. So and the public may not be aware of exactly what's happening with.
No, it's hard to. I don't blame people very much. They're busy.
Yes,
they
it's
got
hard
a
to
lot on
follow.
their minds. There's so much news these days, but you're quite right. People aren't following the blow by blow on this stuff.
But bottom line, you're confident that the Supreme Court is going to handle free speech issues wisely and well in the years ahead.
Well, that's a big statement, but I'll sign on about 80%. I think in the free speech area, if you care about old-fashioned free speech values, this is a good court. On lots and lots of other stuff, this is a court where 5 Republican appointees dominate the court and vote in a generally conservative direction. So if you're conservative, you should be happy with this court. If you're a liberal, you should be a little less happy with this court. But as you were suggesting earlier, Sandy, that kind of breaks down on free speech issues. And if you believe in old-fashioned free speech values, which is not everyone does, and a lot of liberals less and less, but if you believe in them, this is not a bad court.
Of course, liberals are not. It's not going to be a comfortable position for liberals to have to defend a relativistic position on free speech, even though there are other values, as you say, that young people are especially concerned about. It's going to be hard for liberals to defend that they only support some free speech and not other parts of it.
You might think it would be hard, but people manage.
Thank you, Adam.
Great to be here.
We've been discussing the Supreme Court's jurisprudence on First Amendment issues with Adam Liptak from the New York Times. To learn more about Georgetown University's Free Speech Project, please visit our website. Thanks for watching. I'm Sanford Unger.